Hello, my name is Professor Shiladitya Rakshit and the module is the customary principles of IHL and the evolution part 2 within brackets ICRC rules. Module overview. This module will discuss the customary principles of IHL as enumerated by the Manual on Customary International Humanitarian Law provided by the International Committee for Red Cross ICRC. We will discuss in brief and principle the 6 major parts in which all the customary rules are divided in the study by ICRC. Learning outcomes. To give students an overview of the major principles identified by ICRC customary rules. By the end of the module, the students of this module will have a basic understanding of the concepts that have developed to the level of customary international law in the field of humanitarian law. Introduction. The ICRC customary IHL rules is a study of customary international humanitarian law conducted by the International Committee for Red Cross and published by Cambridge University Press in 2005. It is considered to be one of the most authentic sources on interpretation and identification of principles of IHL and recognized by the international tribunals and countries alike as representing customary principles of humanitarian law. It consists of 161 rules divided into 44 chapters and 6 major parts. For every rule mentioned in the ICRC customary IHL rules, there is a corresponding chapter in second volume of the publications, that is ICRC customary IHL practice. The 6 major parts under which rules are divided include the principles of distinction, specially protected persons and objects, specific methods of warfare, use of weapons, treatment of civilians and persons, hors de combat, and lastly the implementation. Principles of distinction. The first set of rules and perhaps the most important customs are the rules relating to distinction. IHL requires a distinction to be maintained in the targets of the attack. The first distinction is that between civilians and combatants. Chapter 1 of the ICRC rules defines combatants, armed forces and civilians. Civilians ought not be the targets of an attack. The second distinction is between civilian objects and military objectives. Definitions of military objective and civilian objects are extremely vague, allowing a great scope of discussion on classification of objects. Certain objects clearly fall within military or civil objects. However, there are others such as dual use objects whose classification is not so black and white. A legitimate attack is one which only targets a military objective. Chapter 3 of the customary rules prohibits indiscriminate attacks. Attacks that either do not or cannot make a distinction between its targets and indiscriminatory effects, both civilian and military targets are considered indiscriminate. It is a generally accepted principle, as have been discussed in previous chapters too, that an attack has to be proportional to the military advantage it seeks to achieve. The last 2 chapters of the first part discusses the concept of precautions in attack and in effects of attack. As part of precaution, constant care has to be observed, belligerence to avoid or minimize incidental loss to life and civilian objects. They have a duty to verify their targets, and if high incidental damage is anticipated due to an attack, belligerents have an obligation to cancel that attack. In addition to precautions in attacks, the belligerents have duty to ensure that the attacks are executed in a way to ensure minimum damage. They are required to choose targets away from population or removal of civilians in vicinity wherever possible. Specifically protected persons and objects. The second set of rules in the ICRC rules deal with protected persons and objects during an armed conflict. Quite obviously, the first ones on the list are medical personnel, medical activities, medical units, medical transports, along with religious personnel and personnel displaying distinctive emblem. Objects and personnel involved in humanitarian relief and peacemaking missions have protection under the customary rules too. An important protection under the ICRC rules is that of journalists. Journalists are very important for accessibility of the external world in the conflict zones, and therefore have been especially protected under the IHL rules with respect to objects. The IHL rules protect hospitals and safety zones, demilitarized zones or non-defended areas. The belligerents have to be careful with what they choose to attack. Attack on cultural property and places in order to damage the existing heritage and natural environment are not allowed either. 6. Specific methods of warfare. There are certain methods that are prohibited to be used under an armed conflict situation. Using denial of quarter as a threat or attacking hors de combat or persons parachuting from aircraft in distress is disallowed. Hors de combat soldiers are those combatants of adverse party who are either defenseless due to unconsciousness, shipwreck or sickness, or express intention to surrender and sustain from any hostile act and do not attempt to escape. Use of methods such as starvation or restricting access to humanitarian relief is absolutely prohibited under the customary rules. Activities such as pillage of taking war booty or destruction or seizure of enemy property without a military objective are also considered to be restricted methods. The last set of methods which have been considered against honor in ancient times have developed to be a part of custom is use of methods of deception. Methods such as improper use of white flag, improper use of distinctive emblems of Geneva Conventions, improper use of UN or other international recognized emblems or uniforms, concluding agreements to suspend combat with the intention of attack or killing an adversary by resorting to perfidy are covered within the scope of these rules. Is the use of weapons. Perhaps the easiest categories of rules are that of use of weapons. As a general rule, weapons that are of a nature that cause or likely to cause superfluous or unnecessary sufferings are prohibited. Weapons that are by nature indiscriminate, that is, they cannot control the impact of the attack on the military objective. For example, attacks such chemical weapons that cause mass damage indiscriminately is prohibited under such weapons. Over the series of conventions and now a part of customs, weapons involving chemical weapons, poison, expanding bullets, exploding bullets on combatants, biological weapons, booby traps, landmines, incendiary weapons or blinding laser weapons are prohibited. It is quite interesting that nuclear weapons are absent from the list of prohibited weapons. Currently, there exists no customary law that prohibits the use or threat of use of nuclear weapons. The decision by the ICJ on the advisory opinion on legality of the threat or use of nuclear weapons has clarified that position. ICJ in its opinion explained that the use of nuclear weapons is not that clear or direct. If the weapon were of a nature that violates other principles of IHL, that is, if it is indiscriminate in nature, it would still be prohibited under IHL. However, nuclear weapons, if abide by principles of IHL, are not prohibited. Treatment of civilians and persons hostile combat. Chapter 32 of the ICRC rules discusses the fundamental guarantees that international humanitarian law provides for. The first is that of a humane treatment. All civilians and hostile combat are supposed to be treated humanely without discrimination of any kind. Activities such as murder, torture or inhuman treatment, mutilation and medical or biological experiments are strictly prohibited on the said group. Rape and sexual offences, other type offences such as slavery and slave trade, forced labour, hostage taking and using human shields are also prohibited under the IHL rules. There are other set of rights relating to justice that are guaranteed to the host, the combatant and civilians. These guarantees include prohibition against arbitrary deprivation of liberty, prohibition against enforced disappearances, guarantee of fair trial and respect for family life and religious practices amongst others. However, not all captured combatants have the same rights as prisoners of war. For starters, combatants have the duty to distinguish themselves from civilians. If they do not do so, they would not be considered prisoners of war. Combatants caught during espionage, that is spies or mercenaries as defined by Geneva Convention, do not have a status of prisoners of war. In cases of shipwrecks or conflict over sea, all parties to conflict have a duty to take all measures to collect and evacuate wounded, sick and shipwrecked without distinction, provide or allow them to obtain necessary medical care, and protect them from ill treatment and pillage of personal property. The dead have to be collected, identified and cremated with respect, and the remains and personal effects have to be returned. Chapter 37 discusses the treatment of those deprived of their liberty. The parties to a conflict have a duty to provide basic amenities where such persons are held, and women and children must be held in separate quarters from men unless families accommodated as family units. The prisoners have to be located at a place away from combat zone where their health and hygiene can be maintained. Personal details of the prisoners have to maintain, and their personal effects have to be protected from pillage. In order to ensure that persons deprived of their liberty are in conditions prescribed by IHL, ICRC must be granted regular access in case of international armed conflicts and may visit and offer services in a non-international armed conflict. All persons must be allowed to correspond with their families, and those deprived of liberty for non-international armed conflict must be allowed to receive visitors. It is also provided that personal convictions and religious practices of such persons must be respected. Rule 128 lays down that POW must be released after cessation of hostilities. Civilian, internees and persons deprived liberty in relation to non-international armed conflict, when reasons for their internment or deprivation ceases to exist. In addition, Chapter 38 provides that displacement of population either from occupied territory or from owned territory to occupied territory is prohibited unless security of population or military necessity so demands. In cases of displacement, parties have the duty to ensure they are received in good health and hygiene is maintained, and they have the right to return to their homes once the reason for displacement ceases to exist. Property rights of displaced persons have to be respected. The last set of protection offered under the ICRC rules imposes a duty on parties to a conflict to respect special rights and needs of women, children, elderly and the disabled. It further creates an absolute prohibition on recruitment of child soldiers, allowing children to participate in hostilities. 9 is implementation, compliance. The last section of the ICRC rules deals with the implementation of the customary principles of international humanitarian law. It sets down obligations for each party to comply with customary rules irrespective of the reciprocity. States have an obligation to train their military commanders and armed forces about principles of humanitarian law. For the enforcement of the rules, states are required to exert their influence to the degrees possible to stop violations. In absence of provision of international law, belligerent reprisals are subject to stringent conditions. Any reprisals against person or objects is protected under Geneva Conventions are prohibited. Further, the right to resort to belligerent reprisals is only available to parties to international armed conflicts. State responsibility. Customary rules of IHL also define the attribution of responsibilities. Rule 149 expresses that a state is responsible for violation of IHL, including violations committed by the organs, including armed forces, persons or entity empowered to exercise governmental authority. Persons or groups, in fact, acting on its instructions, under its direction or control, and of private person or groups of which it acknowledges adopts as its own conduct. A state responsible for violation of IHL is required to make full repartitions for the loss or injury caused. Repartition for the injury shall be in the form of restitution, compensation or satisfaction, or combinations of these principles. Restitution means re-establishing situation that existed before the wrong was committed. Compensation, as a long-standing rule of customary law is clear, states that violate IHL must pay compensation if required. Satisfaction are required if the violation cannot be made good by restitution or compensation. Satisfaction can include acknowledgement of breach of expression of regret, formal apology or other such form of modality. Individual responsibility. Individuals also criminally responsible for war crimes they commit. For that matter, individuals are only responsible for committing the crime, but also for assisting in facilitating, aiding or abating the commission of a war crime or even its planning. Commanders and other superiors are criminally responsible for war crimes committed pursuant to their orders, or if they know or had the reason to know that subordinates were about to be committing these crimes and did not take measures to prevent them. Subordinates have a duty to disobey an unlawful order, and the excuse of following orders does not discharge them of their criminal liability. War crimes. Serious violations of international humanitarian law constitute war crimes. The commentary to the ICRC customary IHL rules expands the definition of war crimes to deduce what does it actually mean by one. Analyzing the treaties and national legislations, it can be interpreted that if a violation endanger protected persons or objects, or if they breach important values, they would be considered serious. It was laid down in the Tadic case that the violations of rule of humanitarian law must entail criminal responsibility for the individuals involved. War crimes list a lot of crimes. The first set of crimes included in definition of war crimes is that of grave breaches of Geneva Conventions against any protected person or property, which include willful killing, torture or inhuman treatment, willfully causing great or serious injury, extensive destructions, or a portion of property not justified by military necessity, compelling a POW or other protected person to serve forces of hostile power, willfully denying POW rights of fair trial, unlawful confinement, and taking of hostages. A look at the Rome Statute of the International Criminal Court would identify a long list of other serious violations during international and non-international armed conflicts as war crimes. This one section would not be enough to list all crimes that could fall within a definition of a war crime. An interesting concept of customary law that has developed with war crimes is that of universal jurisdiction of states over war crimes. Essentially, what this means is that any state, irrespective of territorial jurisdiction, can prosecute war crimes occurring in any part of the world in their national courts, because the crime is of such a nature that it affects the whole world. States whose nationals commit the crime or on whole territory the crimes occur have the obligations to investigate the crimes and prosecute the suspects. Rule 159 also codifies that after the end of hostilities, states must offer greatest possible amnesty to persons participating in non-international armed conflict if the suspect is not accused of war crimes. Additionally, given the nature of war crimes, it is not treated as any other crimes. The statute of limitation, for instance, does not apply to war crimes. Further, states have a duty to cooperate in order to facilitate investigation of the war crimes and prosecutions of the guilty. Thus, to summarize, in this module, we went through summary of all the provisions existed in the ICRC manual on customary international humanitarian law. First and foremost, we discussed the principle of distinction and its related rules of proportionality and precautions which work together for an act to be legitimate or illegitimate. We understood the difference between legitimate and illegitimate military and civilian targets. We then discussed the protected objects and persons under the customary IHL rules. Following an introduction, we discussed the methods of warfare that are prohibited under the IHL. Principles include attacking defenseless, pillage, inhuman treatment, starvation as a method, and deception amongst others. We discovered that weapons which cause excessive or superfluous injury or are indiscriminate in their nature are prohibited under principles of IHL. Customary rules provide a list of weapons that are prohibited so far. However, nuclear weapons are not yet a part of the list. We then shifted attention to treatment of civilians and hors de combat. We discussed the fundamental guarantees offered to the entire group. We also discovered that certain categories of combatants do not get the status of prisoners of war. These include combatants who do not distinguish them from civilians, spies and mercenaries. We discussed the treatment and rights of detained prisoners and civilians deprived of their liberty and duties and responsibilities of the parties to conventions towards them, and lastly discussed the customary rules of IHL, which comprises on implementation of the principles of IHL. These include mechanisms including requiring compliance followed by stricter mechanisms that results in state responsibility and individual criminal responsibility. We ended the chapter with an understanding about the definition, scope and the implications of crimes that constitute as war crimes. Thank you.